Now we're going to get down to the nitty-gritty of what Indians are all about.
I still say we Indian people are believers in the truth. This is the way of life that was given to your people. You're born an Indian, you're going to die an Indian. Indianness is a good life. You're facing an Indian this afternoon.
Thanks, guys. I appreciate everyone coming together so much. It's one of the most important topics, I think, going on in Indian country, and it's one of the most covered topics I'm seeing in headlines recently. And so one of the elements of reporting on the McGirt case, especially as we have entered this phase where we are seeing large investments being made by tribes in policing and administering justice in Indian country, is really closely tied in historical context. It's safe to say that that's probably the least touched topic that I've seen recently in coverage, because I know a lot of us journalists are out there and we're just trying to get the facts out as concisely as possible. But I really wanted to take the opportunity to provide some education on that historical context and allow journalists some insights into where that leaves us today. And I think Jonadab does a great job in providing that historical context. And can you just kind of walk us through the most kind of concise way to how we got to the McGirt Supreme Court decision? I know there's nothing concise about 100 years of history, but can you kind of touch on that a little bit for us?
Sure. And thank you, Angel, and thank you, Sterling. Just deepest appreciation to the Society for putting this panel together and providing the opportunity to discuss these important issues. Absolutely. Truth-telling and reporting are, in theory, one and the same, and you can't tell truth without understanding context. And that's very important in regards to the McGirt decision, because the McGirt decision that was issued in July was just the latest chapter in a story that extends, frankly, beyond the earliest days of the United States. So it's important to understand that context as we talk about the decision. Let me just start from the beginning very, very briefly. The Muskogee Creek Nation, as we know, was originally centered in Alabama, Georgia, and northern Florida. And we engaged with European nations long before the formation of the United States. Our role in the formation of the United States was critical because alliances with tribal nations were critical to the balance of power as European nations sought to colonize what would become known as the United States. That history led to all sorts of very complicated dynamics leading up to, through the Revolutionary War and then in the early days after the war. Shortly after the war, the U.S. tried to solidify its constitutional form of government, and in doing so, ratified the U.S. Constitution as we know it today. In 1789, the U.S. ratified the modern-day U.S. Constitution. At that time, the United States, this newly formed republic, desperately needed legitimacy on the international stage. It needed to show that it was truly a sovereign nation. And what does a sovereign nation do? It treats and engages in diplomatic relations with other sovereign nations. So treaty making with tribal nations was critical to the legitimacy of the United States on the world stage. I'm very proud to say the Muskogee Creek Nation was the first nation that helped give the United States that legitimacy after the formation of the modern-day Constitution. In 1790, our nation entered into the Treaty of New York, which defined the southern boundaries of the United States. And although in that treaty, there was a promise made by the United States to forevermore, relinquish any adversarial positions. That promise was ultimately broken. Since 1790, the Muskogee Creek Nation has entered into a long chain of treaties with the United States, each of which included significant cessions of land and in return for certain promises made. And each time, in almost every case, those treaties were unfortunately clearly broken. And they were broken in a manner that always resulted in a loss of land, but also further pressure being placed on the Muskogee Creek Nation to give up more land. So you see this driving force stemming from this constant desire to acquire Creek Nation resources, Creek Nation lands, and in many cases, Creek Nation labor, driving policy in the United States. So throughout this series of treaties, we get to the 1866 treaty that's in question in McGirt. And I posted an article that, perfect timing, just came out this morning that talks about the interplay between false narratives and bad policy. And that article lays out the history of the Removal Act and the false narratives that went into play to purportedly justify the Removal Act. It goes into the false narratives that supported the Curtis Act, which allotted our lands. It touches on the false narratives that have driven much of federal Indian policy that has negatively impacted our nation. That brings us to the lead up to the Murphy and McGirt decisions. And we could spend all hour talking about the torturous procedural history of those cases. But long story short, the cases were continually pushed back because of, as we know now, after the fact, of an apparent deadlock on the court. With the arrival of Justice Gorsuch, who's truly a heavyweight in the Indian law community and a Western appellate judge before joining the court had guidance and understanding of underlying Indian law principles that it never had before. That made the difference. In a 5-4 decision issued July 9th, the U.S. Supreme Court, in a beautifully written opinion issued by Justice Gorsuch, simply applied the law. And it applied the law despite the prevalence of numerous false narratives in the lead up to the case. And in applying the law, Justice Gorsuch talked about this history specifically as it relates to the 1866 treaty, but also the history of these broken promises of the United States, and simply said, at the end of the Trail of Tears, lie to promise. That was important. The actual application of the law in the case wasn't significant in itself. Justice Gorsuch applied, frankly, a textualist approach to the existing body of law. There was an existing body of law called the Solemn versus Barlette line of cases. I think everybody's familiar with it, that simply said that unless Congress shows its face to the world, and I'm summarizing, but unless Congress shows its face to the world in disestablishing or diminishing a reservation, that reservation's boundaries remain in full force and effect. And the court basically looked at the history that applied to Creek Nation, both in terms of federal actions as well as state actions, including the history of allotment, as well as the history of statehood and various other statutes, as well as state actions that the state was using to try to argue that collectively amounted to a disestablishment of our reservation. And what the court did was incredible, not because of its legal analysis, but because of its intellectual honesty in blasting through all the, as some would term, malarkey that's out there, the false narratives that are out there, to show that despite these, frankly, unlawful attempts by the state to exert jurisdiction on Creek Nation lands, and despite the efforts of some to cast this narrative of disestablishment, the court found no disestablishment. Furthermore, the court didn't buy some of the sky is falling narratives that were presented in the briefings of the case. Let me just briefly run through those. In the lead up to the case, the state of Oklahoma, and unfortunately with support of the United States in a friendly brief, an amicus brief, basically pointed to budgetary issues that would be caused by a truthful ruling in the matter, strains on tribal capacity, strains on U.S. attorneys' capacity to do justice on our lands. They created, without any justification, a narrative that criminals would run rampant, that chaos would reign supreme. And those were arguments that we've seen before. We've seen it in Oklahoma before, when there was a foundational appellate court case in the late 70s, the Little Chief case that established that tribal nations did have the authority to have tribal courts. We saw the same malarkey pushed around, saying that there would be chaos running rampant. That never happened. What did happen is the Indian law community bounded together in this newly affirmed right to create a tribal justice system in the western part of Oklahoma, and built a tribal justice system in many of the Western tribes that would have been already healthy and strong had the state and the federal government supported capacity building all along. So we've seen those false narratives rear their head in Oklahoma, and that's certainly what happened in the briefings. But beyond the state of Oklahoma amicus briefs, you had industry writing briefs, and there was an amalgamation of oil and gas and agricultural interests who basically said business will flee eastern Oklahoma if the court upholds its precedents. So please, court, try to find a way to craft some judicial justification, regardless of whatever mental or legal gymnastics it takes, to not recognize that the treaties have never been disestablished. And for that, they again laid forth all sorts of unjustified claims about business running rampant. So it was a double-barreled approach to claim on one end criminals will run loose, and on the other side that businesses will flee. The court didn't buy any of that. And thankfully, they had ammunition not to buy any of that. And there was an amicus brief filed by the National Indigenous Women's Resource Center that showed that disestablishing our reservation would make women less safe and would actually be a deadly blow to public safety. It talked about the trajectory of empowering tribal nations to go after bad guys on the ground, and how that shouldn't be reversed through judicial disestablishment. Then you had numerous U.S. attorneys filing amicus briefs in the case, calling into question and completely dismantling the budgetary arguments that were made by the state of Oklahoma, as well as this narrative of criminals running loose. The court didn't buy.
Can I kind of like pop in here just for a second? Because one of the things that really plays out in my mind as we were following McGirt through the Supreme Court, and this is a question I'd like to kind of pitch to both of you at this point. How rare is it for Indian country that the context and actual text of the law is followed, regardless of the difficulties or these different narratives that were being pitched in argument? You know, how rare is that it actually plays out that way? That seems to be something I think a lot of people missed.
Absolutely. Stephen?
Yeah, if I may, one, I want to piggyback on Jonathan's comments about kind of the mythologies that affect, and this relates as well to your question, Angel. In the context of this case, one of the most pernicious myths that I think has affected perception of the case and some reporting, but I think by and large the reporting has actually been pretty good, is this repetition of, oh my Lord, the reservations are still there. No one thought the boundaries were still there. No one thought that. That is a non-tribal perspective. You look at each of the constitutions of these tribes, they start with a recitation of their treaties and their boundaries. You look at the programs and services that these tribes provide. They reach throughout their areas. So myth number one, this was a great shock. No, it's not. from the tribe's perspective, we've been operating within these boundaries and based on the presumption of our authorities since the state came into being. The issue that makes it more controversial is the Major Crimes Act. And an important contextual point on the Major Crimes Act. The Major Crimes Act was not a statute that was enacted to help tribes. The Major Crimes Act was a statute that was enacted in the late 1800s at a time when the federal government was battling with the states over who was going to have primary jurisdiction in these vague areas called Indian country. By the Supreme Court decision, U.S. v. Kagama, that affirmed the enactment of the Major Crimes Act as a legitimate exercise of constitutional power, has a very interesting discussion if you read it for the context that we're talking about here. The only two sovereignties they cared about were the state and the federal government. They didn't care about the tribes. They weren't part of the analysis at that time. And that's the context that the tribes wrestle with day in and day out, that there's this constant arm wrestling between state and federal, and then the tribes are treated as a bystander, as they were in this case. This was a case between a criminal defendant and the state of Oklahoma. The tribes that participated in this, starting with Muskogee Creek and then each of the 5 tribes and then other tribes across the country, were bystanders as amicus in this proceeding. And that's how these issues play out, and it's a challenge. To your question, Angel, about the kind of how shocking is it? John and I have touched on this with Justice Gorsuch's arrival on the court. The phrase that jumped into my brain back in 2017 when the 10th Circuit decided the Murphy case was intellectual honesty. One of the biggest challenges tribal advocates have had is that law is law, yeah, but when tribes are involved, things are different. And one of the reasons for that is, tribal advocates will bring up terms like colonialism, and it can sound radical or it can sound like you're coming from one end of the spectrum. But that's what federal Indian law is. Federal Indian law implements a set of pre-constitutional rules and is trying to normalize them within our federal constitutional set of state and federal jurisdictions. So when, starting in the 1980s, really 70s, but really getting steam in the 80s, the Rehnquist court kind of embraced that more colonial view of Indian law. And the court embraced its policy-making powers as opposed to its purely adjudicating powers. So rather than looking at the law as it is, the court determined how do they perpetuate the colonial mission of essentially terminating the tribes. So since the 80s, the Supreme Court has been a scary place to go as a tribal advocate. The level of predictability you can apply to how Indian law rules will control in a case, you always have to factor in the politics of it as well. So when Justice Gorsuch applied, which I referred to, that textualist approach, that is fundamental to why McGirt is important. He basically said, look, treaties are laws. Congress acted numerous times with respect to the Muskogee Creek and other tribes. We, the court, have to follow Congress's lead on this. And he strictly hewed to the court's prior tests and to the language of those laws. And when you do that, you get results like McGirt. And that, as a tribal advocate, is remarkably refreshing. And I think when looking at McGirt, there's McGirt's implications for Muskogee Creek. There's McGirt's implications for the 5 tribes generally who share a consistent legal history. And there's implications that McGirt has for Indian country generally. I think if you look at it from Indian country generally, it restores a justification for some faith that law is going to matter when it comes to a fight between a tribe and another sovereign. And that's critical.
I have another kind of that's a segue for me into the ethical obligations of reporting truth and how we hold those in power accountable and to give voice to the voiceless. I'm a citizen of the Muskogee Nation. John Adev is. We can kind of all recall that day when we heard this opinion, but the celebrating or the feeling that a lot of citizens felt when it came to having that affirmation of what we've always known. And I think Stephen did a great job of mentioning that some of our programs are just clustered around this jurisdiction, and that's so much a part of what we do. And service wise, if you live within these boundaries, and you are eligible for help in this way. Can you talk to some extent about that to help people understand the inner workings of that, John? Because I don't think a lot of journalists from the outside looking in really kind of grasped the concept that we've always operated under that standard. No matter what language we use to describe the jurisdiction, it's always been there. Kind of how does the tribe feel about that? You can speak for that.
Absolutely. And I just I forgot to mention how much of an honor it is, in addition to being with you, Angel, and Sterling on this, to be with Stephen. Deep respect for the work that he does. I agree with everything he just said, with the possible exception of the coverage to date being good. I think the coverage to date has been mixed at best.
Mostly good.
Yeah. It has been mixed, and I do think there's an ethical obligation on the part of journalists to not engage in or not perpetuate echo chambers. And the false narratives that I mentioned before continued after the decision was issued. So there's an echo chamber that is created and around this notion of chaos that we have to look within a historical context of why it's there. And why it's there, narrative creation has always driven policy. False narratives have driven bad policy. True narratives have driven good policy. So I think there is an ethical obligation on the part of journalists to dig in and really look at what the truth is. A good example of this was in the Atlantic. Rebecca Nagel, in the lead up to the case, just completely destroyed the state's arguments about thousands of prisoners running in the streets. And how'd she do it? She did it by systemic, detailed data analysis. And she did a sampling of all the records in Oklahoma and found that it was a handful of folks who would simply be subject to another jurisdiction's authority rather than running around on the street. And the answer to going after those folks was intergovernmental collaboration. So when you hear these inflammatory narratives, whether it is, and before the case, people were saying half of eastern Oklahoma was going to go back to the Indians, scaring people, recognizing that the vast majority of people in eastern Oklahoma and throughout Oklahoma are not Native American. Something like that's inflammatory. The counter to that is the truth. Wait a second, not 1 inch of land changed hands, and what we're talking about is jurisdictional power to go after certain crimes. And what crimes are we talking about? Crimes committed by Indians. And what is the answer after McGirt? The answer is, before McGirt, you had one authority, the state of Oklahoma, that frankly had a checkered record about going after these crimes. And after McGirt, you have two superpowers. In our case, the Muskogee Creek Nation, who, as I pointed out before, was one of the foundational tribal nations on this land that has always played a central role in this in this country's history. And on the other hand, you have the United States having concurrent jurisdiction and the ability to share resources and collaborate and coordinate to go after bad guys. So in a very real sense, after the decision, bad guys were less safe and Oklahomans were more safe from a legal standpoint than they were ever before. Now, all that's left after that is implementation. And Creek Nation has invested heavily in implementing its authority and collaborating with its jurisdictional partners. It's created, and Chief Hill's created the Reservation Protection Commission. Other tribes have done something similar. And we're engaged in the day-to-day work with state, local, county, and federal partners to go after bad guys together, to make people safer together, and explore opportunities to incentivize business in Indian country. Tribal nations were the first traders on this continent. Tribal nations were the first entrepreneurs. Creek Nation, just like so many nations, is open for business. So again, this narrative that business is going to flee is malarkey. And I believe journalists do have an ethical obligation to look underneath the echo chamber, recognize why these false narratives get perpetuated, and start looking at the history. On the court side, our nation's court system far predates the state of Oklahoma, but frankly predated Georgia and Alabama. That's the root of our court system. Our trade philosophies predate anything that comes from, the founding farmers. We have a lot to add to the conversation of economic development. We have a lot to add in the conversation of public safety. The answer is collaboration rather than driving false narratives to justify bad policy, whether it's bad legislation or bad actions from the state. I would be very thankful if leaders use the bully pulpit of their offices to encourage county sheriffs, county DA's office to work collaboratively. By and large, most of them have. We have ongoing conversations with the governor, with the attorney general, with the congressional delegation, and with the US AG. But we can't do it alone. The local officers need to do their part to ensure orderly transfer of cases, orderly investigation. If another nation wants any tribe-specific legislation that doesn't impact anybody else, we support that. If another nation wants to work with us to build a framework that keeps us all healthier and safer, we support that. But what we don't want is false narratives driving legislation that, as bad policy always does, seems innocuous on its surface, seems an answer to a manufactured problem, and ends up hurting our ability to build capacity down the road. To last point on that, for all the reasons I discussed before, we are convinced that if people understand the opportunities, not just to Native Americans, but to regular Oklahomans, to flourish together based on this clarity that has been brought by the Supreme Court, all Oklahomans, whether they're tribal citizens or not, will embrace this decision, just as the international community has, and will call people on any false narratives that they try to create. Huge opportunity in terms of economic development, huge opportunities in terms of safety of women, huge opportunities in terms of public safety. So journalists do have an opportunity to correct false narratives, look underneath the malarkey, talk to the tribes, and really learn about our plans to build a better future together. McGirt is an opportunity to flourish, not a problem to be solved. That problem narrative is purposely playing into the hands of folks who would otherwise want to push bad policy.
I have a few questions to elaborate on, but I'll let Stephen, I think you had something to add here.
Yeah, well, specific examples that I think are worth meriting are this notion of business will flee. Milo's iced tea is opening a new plant out in Owasso. I forget the name of the company, but there's a paper pulp company that they're going to have 200 employees. They're opening out somewhere within Cherokee Nation, and they're working with Muskogee Creek and Cherokee Nation to find the high-tech employees they need to operate that facility. This is all happening post-McGirt. Flip side. So when folks ask for specifics, it's not the scare tactic, sky is falling, tends not to have facts behind it.